There's no duty to disclose the absence of a building permit.
None of us trust the person who sells us our house.
Remedy is through the contract, through a purchase and sale agreement that protects the buyer.
You're watching EstatePlansPlus.com.
You're thinking about buying a house, or you've offered to buy. Now, on to the next steps. You're ready to sign a purchase and sale agreement to get the house under contract at the agreed price. But you're not sure how all the contract clauses affect you. You need to know what's important and what to watch out for. This is the story of a couple who wanted to buy a 15-room house on 5 acres in Dover. They signed a purchase and sale agreement. They bought the house. And then they discovered structural defects. The ceilings in the renovated kitchen and Tuscan-style room were in danger of collapsing, and the home sellers had never obtained building permits and certificates of occupancy for the renovated rooms. It would be more cost-effective for them to tear down the Tuscan-style room and rebuild it, which would cost $211,000. You want to save yourself from buying a place that has serious defects that add to the cost of the house and your mortgage payments. By the end of this video, you'll see why you want to talk with your real estate attorney during the weeks and days before you decide to buy a particular house, so your attorney can prepare a purchase and sale agreement that protects you. The people who sold the home in Dover advertised a magnificent young gourmet kitchen and fantastic Tuscan-style 4-season room with authentic brick oven and grill. And during the pre-closing inspection, the home sellers verbally emphasized their renovations. After they realized the ceilings could collapse, the home buyers sued the sellers, but the courts dismissed their claim of fraud.
We do think that there was actionable fraud based upon the representations and the marketing materials touting these renovations, obviously without disclosing no permits and defective construction, and also when Mr. and Mrs. Gagliardi separately escorted the Sullivans around during the pre-closing inspection. And Mr. Gagliardi is promoting the renovations he made in the so-called Tuscan room. Mrs. Gagliardi is promoting the renovations she made.
Well, but they're proud of, I guess a couple of things. One, they like them. They're proud of this room. They've lived in it. If they knew it was structurally deficient, they're risking their own lives living in there. So none of us trust the person who sells us our house. That's why we hire building inspectors, have the termites person come. I don't see this necessarily as fraud. Isn't this what the building inspector is supposed to pick up? Your client is also a sophisticated business person who can afford a building inspector.
Yes, there was a building inspector here. The jury had every right to reject that testimony.
The home buyers did have an inspection of the Dover property before they bought it, but they did not take their building inspector's advice to check the municipal building department records to ensure that any necessary permits were obtained for the renovations. A building permit and approval filed at Town Hall would confirm whether renovations were completed and whether the renovations conformed to building codes. If you don't find a building permit on file for renovations to a house that you're looking at, you have to check further. The courts decided that lack of permits and the faulty work were a failure to reveal, but mere silence or non-disclosure was not fraud. The courts decided the sellers did not make any representations that were intended to cause the homebuyers to believe something that was untrue. So the homebuyers had no case for fraud.
The law on fraud and misrepresentation, as applied to the purchase and sale agreement, is that there is no duty to disclose. There's no duty to disclose the absence of a building permit. And there was an inspection done by the buyer. And the inspector told the
buyer said, hey, check out, we didn't look at the permitting history. You should do that, basically.
Yes.
It's hard to find the line between mere silence and fraud. The court compared 2 cases where a seller knew that their house had termite infestation which a buyer could not readily see, there was no liability for the seller, who did not inform the buyer of the infestation. But in another case, where the question of the dryness of the cellar had been asked, there was special obligation on the brokers to avoid half-truths and to disclose facts that they knew about the problem.
How do you recover if you end up with one of those homes? Well, I'm trying to understand how it should have been remedied, because there's a wrong here, right?
Remedy is through the contract, through a purchase and sale agreement that protects the buyer with representations that appropriate permits were obtained.
The buyers in Dover signed a purchase and sale agreement that released the sellers from any liability. Here's some of what they signed. Buyer acknowledges that buyer has been provided ample opportunity to conduct inspections, and that the seller has no responsibility for any failure by the buyer to exercise inspection rights. Buyer is fully satisfied with the results of the inspections and accepts the premises as is. The buyers are not relying on any representations of the seller or seller's agents, including anything about quality or condition of the premises. Buyer further agrees that the existence of any matter or condition revealed by or which could have been revealed by inspections shall not be deemed a default by the seller. Any statements which may have been previously made by the sellers are specifically hereby voided by this agreement. Seller shall have no obligation to repair any defect. Seller does not warrant or represent that the premises complies with any zoning or building codes. And finally, the provisions of this paragraph shall survive the closing and delivery of the deed.
I'd say conventionally it would be dealt with a purchase and sale agreement that contains provisions relating to the discovery of latent defects, instead of releases, as we had in this case, a purchase and sale agreement that released the seller from all liability.
Did you get that? The buyer signed a contract that released the sellers from all liability. If you're negotiating to buy a house, rather than releasing the sellers, you can ask for a contract clause requiring the sellers confirm building permits for any renovations and that the town building inspector had signed off for the work. And that's just one of the dozens of clauses in the contract that we go over before you sign the purchase and sale agreement. To get the deal done right, take time with a real estate attorney who makes you aware of what you're signing. The unhappy homebuyers in the Dover case who released the sellers in their purchase and sale agreement couldn't claim fraud, but they did come up with another theory that convinced a jury to award them their costs of the defective construction. Spoiler alert, the buyers got more surprises when the courts reviewed the case. If you watch part 2, you'll realize you can't count on courts to save you from defects in the house you buy or from misunderstandings in your purchase and sale agreement.
Click the like button and subscribe to get updates on estate planning and real estate. Attorney Roberts is a member of the Real Estate Bar Association for Massachusetts and the Real Estate section of the Hampden County Bar Association.